Will this be the end of Trump's real estate empire? The real estate empire that Donald Trump has built over decades may be about to crumble. Letitia James is no longer waiting, and the first steps towards seizing iconic properties have already begun. Will this be the end of the Trump era in New York? Today, we'll analyze what's really at stake. Before continuing, leave your like and comment below. What is your opinion about Donald Trump and why?
We have new comments from the AG who brought the civil fraud case that can jeopardize Donald Trump's New York business empire. New York's Attorney General Letitia James saying she's prepared to seize Trump's assets in order to fulfill the more than $350 million fine issued against Donald Trump.
If he does not have funds to pay off the judgment, then we will seek, judgment enforcement mechanisms in court, and we will ask the judge to seize his assets.
Joining me now is Charles Coleman, a former prosecutor, civil rights attorney, and an NBC News legal analyst. Charles, thanks for joining us on this. Appreciate it. I'm just wondering here, and I'm not quite sure if this is what she meant, but she can't necessarily go after his assets if he's in the midst of an appeal. This is if he can't secure an appeal bond, right?
That is correct. He is going to have to try and stave this off as best he can, but please understand that Letitia James is extremely clear.
The legal analyst's three-part framework, liability, damages, collection, is the most analytically precise frame in this clip, and I want to build on it before we proceed because it is the lens through which the structural narrowing paradox becomes most visible. Liability. Judge Engoron found liability in a pretrial ruling in September 2023, granting James partial summary judgment. This phase, establishing that the fraud occurred, was completed before the trial even began. The documented finding was not a close call. Engoron reviewed the financial statements, reviewed McConney's testimony, reviewed the documentary record, and concluded liability was established as a matter of law without requiring a jury. Damages. The February 2024 trial verdict established $354.8 million in disgorgement plus approximately $100 million in prejudgment interest for a total approaching $464 million. This phase produced the largest civil fraud penalty against a private individual in modern New York legal history. The size of the damages reflected the documented scale of the financial benefit. $168 million from Deutsche Bank alone, as I documented in episode 4. Collection. This is where the structural narrowing paradox becomes visible. James had won phases 1 and 2 decisively. Phase 3, actually converting the legal findings into transferred wealth, required navigating a procedural landscape that is, by its nature, more favorable to the defendant than the trial phases were. The reason is structural. Civil judgment enforcement operates on a different timeline than civil trial. The trial phases have clear endpoints. A ruling is issued. The collection phase has no clear endpoint. It is an ongoing process of identifying assets, serving execution orders, litigating enforcement challenges, and managing the defendant's procedural responses. Every element of that process can be delayed by appeals, bond requirements, asset characterization disputes, and corporate structure complexity. For Trump, whose documented financial structure involves a web of corporate entities holding real estate assets, the same structure McConney described in his testimony, the enforcement process required identifying which entities held which properties, tracing ownership through multiple corporate layers, and obtaining court orders at each level, legally available, procedurally complex, and subject to the same appeal and bond mechanisms that produced the bond crisis I analyzed in episode 10. James's statement, "We will ask the judge to seize his assets," was not a threat she lacked the legal authority to fulfill. It was a statement about phase 3 of a 3-phase process in which phase 3 is the hardest, the slowest, and the most easily delayed by a sophisticated defendant with sufficient resources to contest every step. The structural narrowing paradox. The legal system was functioning as designed. The fraud was found, the damages were calculated, and the collection mechanism, operating as designed, allowed delays sufficient to change the political landscape before final enforcement.
There are essentially three elements to a civil trial. First, you want to prove liability, then you want to establish damages, and after you get your judgment, you want to be able to collect. And so Letitia James understands very clearly that this is an important part of the overall puzzle, and everything that she's done and her office has done thus far doesn't mean anything if she doesn't actually get the damages that she has been awarded. And so she's going to fight doggedly for this, but it will take some time because, as you said, with respect to Donald Trump seeking an appeal and then also having to issue an appeal bond, this could be an arduous process.
I want to address the delay strategy analysis and the Letitia James arc as two distinct but analytically connected elements. The delay strategy, the source correctly identifies Trump's legal strategy across all 5 simultaneous cases as delay to election. Let me give that observation the precise analytical framework it deserves. The delay to election strategy is not unique to Trump. It is a documented approach available to any defendant in civil or criminal proceedings who has sufficient resources and a specific electoral timeline that, if reached, changes the legal landscape. What makes Trump's deployment of this strategy analytically distinctive is the documented scale. 5 simultaneous cases across 4 jurisdictions, all being delayed toward a single electoral event, with the documented result that the election intervened before any of them reached the final enforceable outcome that would have been most consequential. The strategy's documented success rate. The federal January 6th charges were dismissed by the DOJ after the election. The Georgia case remains without a trial date. The civil fraud penalty was overturned on appeal, while the fraud finding stood. The hush money conviction stands but carries no sentence. The ballot disqualification was reversed on jurisdictional grounds. The strategy's documented partial failure. The hush money conviction. Despite every delay attempt I documented in episodes 2 and 13, the motions to dismiss, the appeals, the remote sentencing, the unconditional discharge campaign, the conviction was entered and it stands. That is the documented instance in which the delay strategy reached its limits in one of the 5 cases. The James arc as retribution case study. I want to connect this to episode 11's analysis of the retribution apparatus because the Letitia James prosecution arc is the most complete documented case study of the retribution pattern in this series. James is the attorney general who brought the civil fraud case against Trump, proved fraud at trial, won the largest civil fraud judgment against a private individual in modern New York history, and pushed through the bond crisis through the enforcement mechanisms I documented in episode 10. She is also the subject of a mortgage fraud indictment brought by Lindsay Halligan, the constitutionally defective U.S. attorney I documented in episode 11, that was thrown out by courts, rejected by 2 grand juries, and dismissed on the grounds that Halligan lacked lawful appointment authority. Then, by August 2025, the Trump administration's DOJ issued a subpoena to James directing her to produce records related to her Trump prosecution and her NRA prosecution. That subpoena was challenged immediately. A federal judge ruled in January 2026 that the U.S. attorney who issued the subpoena lacked lawful authority to do so. 2 separate attempts by the federal government to use its prosecutorial apparatus against the state attorney general who successfully prosecuted Trump, both blocked by courts, both produced through the same documented mechanism, constitutionally defective or legally deficient appointments or authorizations, both producing documented institutional responses that entered the permanent record alongside the retribution attempts. The James arc illustrates the retribution apparatus's documented operational pattern with complete precision. Find the accountability actor, deploy the federal mechanism, the mechanism fails on constitutional or legal grounds, the failure is documented, the accountability actor continues functioning. The structural narrowing paradox. Full development. I introduced the structural narrowing paradox in the hook. Now let me develop it fully because it is the analytical frame that makes the 2 cases, civil fraud and ballot disqualification, most coherent when examined together rather than individually. The structural narrowing paradox operates through a specific mechanism in each case. In the civil fraud case, the wrongdoing was established through evidence. The liability finding was made as a matter of law. The damages were calculated precisely from documented financial records. The penalty was then reduced by the appellate court on constitutional proportionality grounds. The Eighth Amendment's prohibition on excessive fines, requiring that disgorgement penalties reflect proportionate harm rather than total economic benefit to the fraudster. The fraud is documented, the harm to the fraudster from the legal process is reduced. The constitutional principle the appellate court applied, that penalties must be proportionate to documented victim losses rather than total economic gain, is real, is documented, and is the correct legal standard under existing Eighth Amendment jurisprudence. This is not a case where the court reached the wrong constitutional conclusion. It is a case where the correct constitutional conclusion produced a smaller financial consequence than the documented scale of the fraud warranted under a different legal theory. In the ballot disqualification case, the wrongdoing, the conduct constituting insurrection, was established through 5 days of evidentiary hearings by the Colorado courts. The Section 3 finding was made. The disqualification was ordered. The Supreme Court then reversed the disqualification on jurisdictional grounds. States cannot enforce Section 3 against federal candidates, without addressing whether the Colorado factual findings about insurrection were correct. The constitutional principle the Supreme Court applied, federal candidates' eligibility must be governed by national uniform standards rather than state-by-state determinations, is also real, also documented, and also reflects a legitimate constitutional concern about electoral chaos. This is not a case where the court reached the wrong constitutional conclusion about jurisdiction. It is a case where the correct constitutional conclusion about jurisdiction produced the elimination of the accountability remedy that the underlying facts, if addressed on the merits, might have supported. In both cases, the constitutional framework, the Eighth Amendment, the federal election structure, produced outcomes that narrowed or eliminated accountability remedies while leaving the underlying factual findings of wrongdoing intact. That is the documented structure. And it is analytically important because it is not the result of constitutional error or bias. It is the result of a legal system applying correct legal principles in ways that, when applied to these specific facts, produce the structural narrowing paradox. What they establish. Going forward. The source correctly identifies the precedential significance of both cases. I want to develop that analysis with more precision. Trump versus Anderson as precedent. The ruling establishes, with unanimous Supreme Court authority, that states cannot enforce Section 3 against federal candidates. That precedent governs every future application of Section 3 to a presidential or congressional candidate. For Section 3 to be used as an accountability mechanism in any future insurrection scenario involving a federal candidate, Congress would need to pass prospective legislation specifically authorizing federal enforcement proceedings, legislation that, as the liberal concurrence documented, the political dynamics of a divided Congress make nearly impossible to pass in advance of any future insurrection. The documented constitutional consequence? Section 3 exists as a constitutional provision. Its text prohibits insurrectionists from holding federal office, and the enforcement mechanism for applying it to federal candidates now requires a form of congressional action that the current legal and political environment makes unavailable. The provision is real. The remedy is foreclosed absent new legislation. The civil fraud appellate ruling as precedent, the appellate court's finding that disgorgement penalties must be proportionate to documented victim losses rather than total economic benefit, shapes how future civil fraud cases under New York Executive Law Section 63 to 12 can be charged, and how penalties can be calculated. It establishes that a state attorney general proving fraud that benefits the fraudster financially, without identified specific victims who suffered documented losses, can pursue disgorgement, but the penalty must reflect proportionate harm. The documented consequence. The accountability mechanism for public fraud without identified victims is real and available. The penalty it can produce is constrained by a proportionality requirement that the Engeron judgment, as drafted, did not satisfy. Future cases charging similar conduct will need to calculate penalties within that constraint from the outset. Together, the two precedents draw constitutional lines that narrow the accountability mechanisms available for the specific categories of conduct they addressed: electoral insurrection and financial fraud benefiting the fraudster. Both underlying categories of conduct remain legally cognizable. both accountability mechanisms remain available, the remedies they can produce are more constrained than the Colorado courts and Judge Engeron assessed them to be. A systemic analysis. The source asks a documented institutional question that deserves precise treatment. Is a legal system in which a defendant can delay 5 simultaneous cases long enough to win an election that ends most of the proceedings a system with too many delay mechanisms? Or one that, despite those mechanisms, ultimately succeeded in convicting him in at least one case? I want to give that question the analytical precision it deserves rather than the rhetorical framing it usually receives. The delay mechanisms in American civil and criminal proceedings exist for documented constitutional reasons: the right to appeal, the requirement of appellate bond before enforcement, the ability to raise successive legal challenges. These are not administrative conveniences. They are constitutional protections against wrongful conviction and wrongful enforcement that serve all defendants, not only powerful ones. The constitutional design deliberately makes finality difficult to achieve quickly because the cost of irreversible wrongful conviction is higher than the cost of delay. The documented problem in Trump's case is not that these mechanisms exist. It is that their cumulative effect, applied simultaneously across 5 cases by a defendant with sufficient resources to contest every procedural step, produced a timeline in which the election intervened before any case reached the final enforceable outcome that would have been most consequential. That is a documented structural problem that exists at the intersection of constitutional procedural protections and sufficient resources and political timing. It is not a problem that can be solved by eliminating the constitutional procedural protections. Doing so would harm defendants who lack Trump's resources far more than it would constrain Trump's specific strategy. It is a structural tension that the legal system, as designed, does not fully resolve. What the documented record shows is that the strategy had documented limits. The hush money conviction stands. The fraud finding stands. The Colorado insurrection findings are in the permanent record. The accountability produced by the legal process is real, documented, and permanent. The remedy, collection of the full penalty, removal from the ballot, did not fully materialize. Both things are simultaneously true. Where episode 14 fits, this episode adds 2 analytical dimensions to the 14-episode series that were not fully developed in the original 13. First dimension, the ballot disqualification case, Trump vs. Anderson, completes the constitutional constraint analysis I have been building across the series. Episodes 1 to 13 documented judicial constraints on executive authority, civil fraud findings, immunity rulings, IEEPA rulings, injunctions. Episode 14 documents the other side of the constitutional ledger, a Supreme Court ruling that narrowed a constitutional accountability mechanism rather than constraining executive overreach. The court's role in this series has been primarily as a constraint on the administration. Trump v. Anderson documents the court also operating as a structural limiter on accountability mechanisms, a different function but an equally documented one. Second dimension, the James full arc. From 2018 campaign through proven fraud, through penalty overturn, through DOJ retribution attempts, through federal judicial blocking of those attempts, is the most complete documented case study of the retribution apparatus I analyzed in episode 11. Where episode 11 identified the pattern abstractly across multiple targets, episode 14 traces the full arc of the most prominent single target from the beginning of the accountability effort through the retribution attempts and their documented institutional failure. Together, these 2 dimensions complete the analytical picture the series has been building, a constitutional system that simultaneously constrains executive authority and constrains accountability mechanisms, that confirms wrongdoing while narrowing remedies, and that produces retribution against accountability actors, while those retribution attempts are blocked by the same institutional architecture that the administration has been attacking. The structural narrowing paradox and the retribution apparatus pattern together describe the documented operational reality of constitutional accountability in this moment. The accountability is real, documented, and permanent. The consequences are incomplete, contested, and ongoing. Let me state precisely what the documented record from this episode establishes. 1. The civil fraud case produced a documented 3-phase outcome. Phase 1, liability, established by summary judgment in September 2023. Phase 2, Damages, established at $354.8 million plus interest in February 2024. Phase 3, collection, produced a bond crisis, a Westchester lien, a 30 insurance company rejection, a court-appointed monitor, a fire sale rejection, a bond reduction to $175 million posted through a California auto lender, and an August 2025 appellate ruling vacating the penalty as constitutionally excessive under the 8th Amendment while unanimously upholding the fraud finding. The penalty is under recalculation. The fraud finding is permanent. 2. Section 3 of the 14th Amendment was enacted in 1868 to prevent former Confederate officials who had taken oaths of loyalty to the United States from returning to government. The Colorado District Court found, after 5 days of evidentiary hearings, that January 6th was an insurrection, and that Trump's words and deeds were a substantial contributing cause of it. The Colorado Supreme Court found Section 3 applied and disqualified him. The United States Supreme Court unanimously reversed the disqualification, not by finding that January 6th was not an insurrection, and not by finding that Trump did not engage in it, but by finding that states cannot enforce Section 3 against federal candidates. 3. The Supreme Court's majority opinion went further than the 3 liberal justices believed was necessary, specifying that congressional enforcement of Section 3 would require prospective legislation. Justices Sotomayor, Kagan, and Jackson documented their documented concern. This effectively nullifies Section 3 as a practical accountability mechanism for future insurrections involving federal candidates, absent congressional legislation that divided political dynamics make nearly impossible to pass in advance. 4. Trump's legal strategy across 5 simultaneous cases, civil fraud, ballot disqualification, hush money, federal January 6th, Georgia racketeering, was to generate enough procedural delay that the election would intervene before any reached final enforceable outcomes. That strategy largely worked. The documented partial failure, the hush money conviction, which stands with the unconditional discharge documented in Episode 2. 5. Letitia James's full arc, 2018 campaign commitment to investigate Trump, fraud proved at trial, penalty overturned while fraud finding stood, mortgage fraud indictment brought by constitutionally defective U.S. attorney and dismissed, subsequent DOJ subpoena to her records blocked by a federal judge, is the most complete documented case study of the retribution apparatus I identified in Episode 11. 6. Both cases together illustrate the structural narrowing paradox. The legal system confirmed the underlying wrongdoing in both. The fraud finding is permanent. The Colorado insurrection findings are in the permanent record, while narrowing or eliminating the most consequential remedies. Accountability confirmed. Consequences incomplete. The source material closes with a specific question that I want to answer precisely. Is a constitutional order that can find fraud without collecting it and find insurrection without disqualifying the insurrectionist a system that holds power accountable, or one that produces accountability on paper while protecting power in practice? The precise analytical answer: it is a constitutional system that is doing both simultaneously, because the same constitutional principles, the 8th Amendment proportionality requirement, the federal elections structural uniformity requirement, that produce the structural narrowing paradox also protect defendants with fewer resources than Trump from the worst outcomes of prosecutorial overreach. The constitutional design was not optimized for the specific scenario of a powerful political actor simultaneously facing 5 accountability proceedings while running for an office whose attainment would change the legal landscape. That specific scenario produced the documented outcomes we have examined. The constitutional design did not fail. It produced results that were constitutionally correct and institutionally consequential in ways that the most severe accountability advocates found inadequate. The fraud is documented. The insurrection findings are documented. The remedies are incomplete. The man is in the White House, and the constitutional record across 14 episodes of documented analysis is permanent. This is Matthew John Turner. The question I leave you with connects the structural narrowing paradox directly to the series' central analytical question. If the constitutional system confirms wrongdoing while narrowing remedies, what institutional mechanism remains adequate to the documented accountability gap? The answer, across 14 episodes, is the same same answer I have been building towards since episode 3, November 2026. The congressional mathematics is where the gap between documented wrongdoing and adequate remedy is most directly addressable. Go read Trump versus Anderson, read the majority opinion, read the Sotomayor